Hey guys, what's up and welcome back to EconRecaps. Today, we're going to do something called a Saturday Deep Dive, where we dig a little deeper into a story that we covered earlier this week. We're excited to start the series out focusing on Google's monopoly and the two active antitrust cases related to their Google search and Google advertising. However, before we get into the details regarding these cases, we need to understand the laws that were even broken.
So what is the Sherman Antitrust Act? Approved on July 2, 1890, the Sherman Antitrust Act was the first piece of legislation that outlawed monopolistic business practices. Most often, violations of Sections 1 and 2 are cited when an antitrust lawsuit is brought up against a company. Section 1 pertains to contracts that, and conspiracies to, restrain trade or commerce. Being such a broad definition, the courts have interpreted the law to only prohibit unreasonable restraints. This includes price fixing, bid rigging, and market allocation amongst competitors. Section 2 of the Sherman Act prohibits the monopolization, attempted monopolization, or conspiracy to monopolize an industry or market. Unlike Section 1, no proof of a contract or agreement is needed for a guilty verdict. Actions deemed illegal by Section 2 are exclusive dealing arrangements, tying products together, predatory pricing, refusals to deal with competitors, and leveraging monopoly power in one market to gain an advantage in another. So what's the punishment for violation? Well, the Department of Justice determines criminal prosecutions and penalties. Criminal penalties for violations of Sections 1 or 2 include fines up to $100 million for corporations, fines up to $1 million for individuals, and prison sentences of up to 10 years. If those are deemed insufficient, given either the scale of the violator or the severity of the violation, enhanced criminal penalties can be enacted. The maximum fine may be increased to twice the amount gained from the illegal acts or twice the money lost by the victim if either of those amounts exceed $100 million. Lastly, there are civil penalties, which allow private parties to sue for triple damages and courts to issue injunctions prohibiting anti-competitive practices.
The U.S. Department of Justice, joined by 11 states, filed a lawsuit against Google in October of 2020, alleging that the company had violated Section 2 of the Sherman Act by unlawfully maintaining a monopoly in 3 product markets: general search services, search advertising, and general search text advertising. Shortly after, 38 more states filed a separate but related lawsuit, adding claims about Google's conduct related to specialized vertical providers, which are just specialized search engines like job search platforms or vacation finders, and its SA360 advertising platform. The plaintiffs argued that Google achieved and maintained its monopoly through exclusive distribution agreements with browser developers, mobile device manufacturers, and wireless carriers. Google paid Apple billions of dollars annually for these default placements, with the payments totaling over $26 billion in 2021 alone. The Google-Apple Internet Service Agreement, or ISA, was a central focus of the Department of Justice's antitrust case, as the agreement made Google the default search engine on Apple's Safari browser across all Apple devices, and prevented Apple from preloading any competing search engines on these devices. Google paid Apple billions of dollars annually for this exclusive placement, with payments tied to advertising revenue generated from searches on these Apple devices. The DOJ argued that this agreement was particularly significant due to Apple's large market share, effectively locking out competitors from a substantial portion of user searches, and limiting their ability to improve or compete against Google. Evidence presented showed that Google's market share in general search services grew from 80% in 2009 to nearly 90% by 2020, with an even higher share of mobile devices at almost 95%. Microsoft's Bing, the second-place search engine, only saw about 6% of all online searches. Google's defense centered on the quality of its search engine, its continuous innovation, and the competitive nature of its agreements with partners. The courts agreed and found that Google had achieved its dominance through skill and business acumen. However, the courts did find that its exclusive agreements had anti-competitive effects. Judge Mehta eventually ruled that Google had violated Section 2 of the Sherman Act. She found that there are relevant product markets for general search services and general search text ads, that Google had a monopoly power in these markets, and that Google's distribution agreements are exclusive and anti-competitive. The court also determined that Google had exercised its monopoly powers by charging super competitive prices for general search text ads. Super competitive pricing refers to prices that are higher than what would exist in a competitive market. In the Google antitrust case, the court found that Google exercised its monopoly powers by charging these high prices for general search text ads, allowing the company to earn monopoly profits. This finding was a key factor in determining if Google had violated antitrust law by maintaining a monopoly in the search market. The ability to sustain super competitive prices is often seen as evidence of a market power and can be a red flag for any antitrust regulator. However, the court did rule in Google's favor on some points. It found that while there is a product market for search advertising, Google lacks monopoly power in that market. It also determined that there is no product market for general search advertising and that Google is not liable for its actions involving SA360. The ramifications of being found guilty are significant for Google. The court's ruling opens the door for potential injunctive relief and structural remedies to address the anti-competitive effects of Google's conduct. This could potentially force Google to change its business practices and may impact its dominant position in the search market. The next step for Google will likely involve appealing the decision while also preparing for the remedies phase of the trial. Google may need to propose changes to its distribution agreements or other business practices to address the court's concerns. The company will also need to consider how to maintain its market position and profitability while complying with any eventual court-ordered remedies.
The second antitrust suit was filed on January 24, 2023, related to Google's advertising practices. Specifically, the U.S. Department of Justice and attorneys general from 8 states have filed a civil antitrust lawsuit against Google for monopolizing multiple ad tech products. The complaint alleges that Google has violated Sections 1 and 2 of the Sherman Act by engaging in anti-competitive practices over the past 15 years. 4 main actions are believed to have stifled competition. First is acquiring competitors to gain control over key digital advertising tools. The case cites Google's acquisition of DoubleClick in 2008, giving it control over the dominant publisher ad server, DoubleClick for Publishers, and an ad exchange, AdX. The second is forcing website publishers to adopt Google's tools by conditioning access to Google's advertiser exchange on the use of its publisher ad server. Basically, Google tied the demand for its ad space to its ad exchange and publisher ad server. This forces publishers to use Google's tools to access its advertising demand. Third is distorting auction and competition by limiting real-time bidding to its ad exchange. The complaint alleges that Google manipulated ad auctions and fees to disadvantage competitors and maintain its dominance. And lastly, manipulating auction mechanics to insulate itself from competition. Google allegedly prevented rival ad exchanges from accessing its advertising demand and publisher inventory. In short, they could not access the advertising space available to other bidders. The suit alleges that these anti-competitive practices have resulted in higher fees for advertisers, lower revenues for publishers, and reduced innovation in the ad tech industry. The DOJ has asked the court to break up Google's online advertising business by ordering Google to divest its ad manager suite, including its DoubleClick ad server and AdX ad exchange. They have also left the door open to order other structural relief as needed. Lastly, the DOJ is making monetary claims on behalf of the US government in its capacity as an advertiser. The case is currently being heard but is still under seal. Hopefully the developments will be made public in the next couple of weeks, and the impact this will have on the online ad tech space will be more well known. In order to hear more about these developments, make sure to subscribe and hit the bell icon, as we will certainly be talking about these more going forward. Thank you for watching and have a great day. Cheers.